Hi, thanks so much for joining our webinar this morning. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful Alex Barthet, a Florida construction lien law expert. Today's webinar topic is how do I get paid after recording a lien? So without further ado, I'd like to introduce the fabulous and wonderful Alex Barthet.
Thanks, Jesse. My name is Alex Barthet. I am a board certified construction lawyer here in Florida. And today we're going to talk about how do you get paid after you record the lien. So let's get right into it. If you have questions, you can submit them through the GoToWebinar chat box, which should be on your screen. We will answer all the questions at the end. Please do not include the names of any people or companies in your questions. So what are we going to talk about today? So we're going to talk generally about what a lien is and how it works. We'll talk about what happens after you record a lien, which most people don't know about. And then we'll talk about the reason we're all here, which is how to get paid once you record a lien. Then we'll go through some scenarios that are pretty common that happen after you record a lien, which is someone bonding off your lien. What does that mean and how does it work? And ways that people can shorten the time that you have to enforce your lien, either through a notice of contest of lien or a 20-day summons. And of course, we will answer all of your questions at the end. So what is a lien? It is an encumbrance on real property. It is just like a mortgage. It acts as a placeholder at the date and time, either when the notice of commencement is recorded or when the lien is recorded. And it puts the world on notice that you, as the lienor, have an interest in that property up to the amount of your lien. So what does it do? It prevents people from selling the property at an arm's length transaction. They won't be able to get title insurance if that lien is there and unresolved. It will prevent people from refinancing the property, again, in a standard arm's length transaction with a conventional lender. That lender is going to want to be in first place, just like the buyer of the property is going to want to make sure that there are no clouds on the title, no way that someone can come back and claim that they have an interest in the property. That's why those liens need to be resolved. Those liens being your lien. It is also a technical default under most mortgages. So when you record a lien on a piece of property, the lender of that property, again, it could just be a first mortgage, a second mortgage, a construction loan. Those lender documents require that the owner of the property keep the property free and clear of any liens. So by you recording a lien on the property, that is a default, an issue of default for the owner of the property, because now they have a lien on the property that they have to take care of. If you are a subcontractor or a supplier to a subcontractor, there's probably a provision in the prime contract between the owner and the contractor, or the contract between the subcontractor and the GC, that says that they need to keep the property free and clear of liens. So if that's the case, then your lien creates a default situation for that prime contractor or that subcontractor, and they have to take care of your lien. So what happens after you record the lien? Now remember, to record a lien, you need to follow all the steps. That's, you can go to either the SunRay website or to our Lien Zone website and get all the rules. But for the purpose of this presentation, I'm going to assume that you understand those rules. But once you record the lien, nothing happens. It is a document that is prepared and recorded in the public record, and it just sits there. So unless the lien itself creates a problem for one of those people I mentioned, the lender, the owner, the contractor, or the subcontractor, where they need to take care of the lien, nothing happens. So let me give you the converse scenario to explain why I mean nothing happens. Let's say you do work on a piece of property and there's no mortgage, there's no loan. You record the lien because you have a contract with an owner. They don't want to pay you. You record a lien for $100,000 on a piece of property, and it just sits there. If the owner of that property is not going to refinance, not going to sell, then nothing happens. So it is up to you to enforce your lien, because if the act of recording the lien doesn't cause you to get paid by itself, and in most instances it does, by the way, because almost always there is a lender, there is an owner, there is a GC, there is a subcontractor where your lien is going to impact their ability to either continue to do work, continue to get funding, continue to be paid. So usually your lien will irritate those people enough that they're going to want to try to resolve it. So how do you get paid? As I told you, recording the lien in the public record is just the start of the process. So it's up to you to enforce your lien through a civil court action known as a foreclosure. This legal action can be combined with other legal actions. So for example, if you have a lien on a property because you're a supplier to a subcontractor on a job, you would bring an action to foreclose the lien against the owner of the property. You may also bring a claim for unjust enrichment against the owner of the property. That's, I provided my stuff to you, the owner. It improved your property. You should pay me the fair value of the property. Again, it's a separate legal theory from the foreclosure, which is governed by the lien law. You may also have legal claims against the party that hired you or bought the materials. You may sue them at the same time for breach of contract, for goods sold and delivered, for accounts stated. Again, all of these are various different legal theories. You can sue for some of them or all of them in conjunction with your foreclosure. But the foreclosure action, which is asking the court to determine that you have properly complied with the lien law and therefore you have an interest in the property and that property should be sold in order to pay you. That's the foreclosure legal theory that you need to pursue. That needs to be brought no later than 1 year from the recording date of your claim of lien. That is the outside deadline. You do not need to wait an entire year to sue. You can bring that action within days of recording the claim of lien, or you can do it within months. You just cannot do it later than 1 year from the date of recording the claim of lien. Now, this period of time can be shortened. And we're going to talk about the two ways that 1 year can be shortened at the end of this presentation. But you have that 1 year to file that foreclosure action. So we recommend, we are a construction-only law firm. We have a dozen lawyers that do nothing but construction, litigation, and collection work for our construction clients. And after doing this for 30 years, I will tell you, this is what we see works the best. We call it the 60-60 rule. We think that you should, no later than 60 days from your last work, start the lien recording process. Again, the rule is that you must do it no later than 90 days from your last work. That's the outside-most deadline that you have. We don't think you should wait that long. You can, of course, do it sooner. You can do it while you're working if you want. But we think no later than 60 days from your last work, you should start the process of recording a lien. By the time you compile the records, prepare the paperwork, sign it, notarize it, and record it, that's going to take a week or so at a reasonable pace. Again, it can be done in a day if everyone is on their toes. But to avoid the rush, we think you should start at about day 60. Then, for the next 60 days thereafter, after you record the lien, you should internally hassle your customer and the owner for payment. Phone calls, emails, text messages, visit your customer, visit the owner. Do whatever you can on your own to do as much as possible to try to get paid. That will go a long way at avoiding the need to file a lawsuit. By the way, that may also allow you to get partial payments. So maybe you're owed 100 grand and your efforts reduce it by 60,000, so you're only owed 40 that you may have to pursue in a litigation. But at some point in that 60-day period, if you have not made any progress at getting any payments or partial payments, that's when we recommend you say, okay, you know, if we want to pursue the claim, we're going to pursue it through a construction lawyer for collection. And again, unless you have a business reason to wait, I do not recommend waiting to the outside deadline of the 1 year to enforce your lien rights. Now, you may decide, I'm owed 20 grand on this job. I have 4 other jobs with this contractor. I lien for the 20. You know what? I'm just going to keep waiting because I have a good relationship. I think I'm going to get paid. I've got this other work. That's, in my opinion, a legitimate business reason. But if you're waiting just for the sake of waiting in the hopes that you get paid, we see that as a mistake. If you truly want to get paid, the sooner you act to get paid, the better off you are at increasing the likelihood of getting paid. Now, the lien law is complicated, so we have lots of tools on the Lien Zone website. One of them is called the Calculien. It helps you calculate the 45 days from first work to serve your notice to owner, as well as the 90 days from last work to calculate when your claim of lien or bond claim, the notice of non-payment, is due. We've passed out probably 20,000 at this point over the last 30 years. You can get yours for free at calculien.com. Just go to that website, type in your information, and we will put one in the mail to you. You can also browse the site. We have lots of other free tools to help you understand the lien law and improve your collections and your contracts. So let's talk about 3 of the things that we see happen once you record your lien and how to deal with them. So number 1, someone either threatens to or in fact bonds off your lien. What does that mean and what should you do? In my opinion, if someone actually bonds off your lien, you should be happy. You should celebrate. And the reason is that you have to understand how the foreclosure process works. So let me give you a worst case example of why having a lien on a property may be worthless. So let's assume you've done $100,000 worth of work and you haven't been paid. You've recorded a lien on this piece of property. Let's assume it has a market value of $1 million. But let's assume it has $900,000 or $950,000 worth of loans or other liens on the property that are ahead of you. So if you institute your foreclosure proceeding, we file the lawsuit, we get the judge to agree that you're entitled to the money, the judge orders a foreclosure sale. What happens? At the foreclosure sale, your lien amount, so again, just for simplicity, let's say it's $100,000. You're also entitled to legal fees, costs, and interest, but again, for simple math, let's call it 100 grand. Your $100,000 becomes the first bid to take the property. Well, if we go by my math, your $100,000 plus $900,000 worth of other liens means that there's no equity in this property. Well, in order for you to be paid, some third party in the universe at this online foreclosure sale has to be willing to pay at least $101,000 to buy the property, right? Because they got to show up to the clerk's office, they got to bring a check enough to pay to bypass your bid, right? Your bid was 100 because that's your lien amount. That's what the judge ordered. So they need to bid 101. Well, if they bid 101, they still have to deal with the $900,000 mortgage that's ahead of you, right? It doesn't go away. That prior mortgage doesn't disappear because you've started your foreclosure process. So as a result, no one is likely going to bid on the property. So you may end up taking the property, meaning no one else bids. Your $100,000 is used as a credit bid to take ownership, and then now you are the owner of the property. But you own a piece of property that has a $900,000 mortgage, and if you don't make a deal with the bank, they're going to foreclose you out. That may take several months, but you will not own the property because they will foreclose because someone has to pay that mortgage. So understanding that that's the way a foreclosure works, if there's no equity in the property, then if someone bonds off your lien, the reason you should celebrate is because for them to bond off your lien, they have to go to the clerk's office and either with a surety bond or a cash bond off 150% of the lien amount. So if we go back to my example, you have a $100,000 lien, they have to go to the clerk's office with roughly, there's a specific formula, but it almost always works out to be about 150%. So they got to show up to the clerk's office with $150,000 of a surety bond or cash. Now your lien is no longer on the property, it is connected to this surety bond or cash bond. So when you foreclose and you win your case and the judge says you're entitled to your money, you don't have to worry if there's any equity in the property because you have this little pot of money that's been set aside just for you to pay you if you win. So when someone says that they're going to bond off your lien, I tell my clients, fantastic. Tell them how quickly can they do it and send us the paperwork right away so that we know that it got done. Now, one of the things I will tell you is that when someone actually bonds off your lien, you should file your lawsuit to foreclose right away. If they wanted to work it out, they would. They don't want to work it out. That's why they've gone through the effort of preparing the necessary paperwork, filing it with the clerk, getting a cash or a surety bond, and posting that with the clerk. So you should file your lawsuit right away. So anyone that bonds off your lien, you should waste no more time trying to collect, and you should send it to your construction lawyer right away to start the lien foreclosure process against that transfer bond. So what are some of the other things that we see happen once you record your lien? After bonding off, the next most common is the owner or the contractor shortening the time that you have to file your lawsuit. Remember, I told you you have 1 year to file your lawsuit from the recording date of the claim of lien. But an owner can serve a document called a notice of contest of lien. This will reduce the amount of time you have to file your lawsuit from 1 year from the recording date down to 60 days from the day that that notice of contest of lien is recorded with the clerk. Now, a notice of contest of lien is prepared by the owner, brought to the clerk's office. The clerk will stamp it and record it and then put it in the mail to you at the address that is listed in your notice to owner. When you receive it, the clock has already started. The clock starts based on the date that the clerk stamps it as mailed, okay? Not the day you get it, the date the clerk stamps it. So when you get it, there'll be a stamp on it. It'll have a date. That's the date you're going to count 60 days. 60 days is every day, including weekends and legal holidays, except for the last day, the 60th day, which may roll over to the next day, depending on if the 60th day, for example, is a Sunday, it'll roll to the Monday. If you do not file your lawsuit within those 60 days, your lien is automatically discharged without any further intervention by the court. So if you get a notice of contest of lien, you should file your lawsuit to foreclose right away. Now, 60 days may be too long for some people. So sometimes an owner will send what's called a 20-day summons to show cause. If you get one of those, what should you do? Just like the notice of contest, you should file your lawsuit immediately. So again, the rule is 1 year from the recording date of the claim of lien is when you normally have to sue to foreclose. However, if you receive this summons, you only now have 20 days to file your lawsuit. And just like the 60-day notice, if you don't file a foreclosure action within the 20 days, your lien will automatically be extinguished. The 60-day notice is you will receive that via certified mail. The 20-day summons will be served upon you by the sheriff or a process server because it is actually a lawsuit. The 60-day notice is just recorded in the clerk and sent to you via certified mail. The 20-day summons is actually a lawsuit. So you will be named as a defendant in the case and served by the sheriff or a process server. So with that, Jesse, do we have any questions?
Well, first of all, thank you so much, Alex. As always, you're incredible and remarkable at breaking it down and showing us some of those nuances involved. We do have a couple of questions that have come through. The first one, it says, if the property owner is applying for a loan at the end of a project to make payment, can the lender force the GC to record a notice of termination before providing the loan?
Okay, so the short answer is maybe. It really depends on your average job. The answer is no. Let's put it this way. Your average smaller project, the answer is no. On larger multifamily and condominiums, lenders sometimes get what's called a lender consent or a will serve letter. So that's a separate agreement between the lender and the contractor that may give the lender some more rights, but let's put that lender consent document on the side. In your average situation, the answer is no. You don't have to do it as a contractor or lien, or you can say, no, I have my lien rights, so I will only release my lien if I get paid. So you have some rights for you to avoid having to consent to the termination of the notice of commencement. And by the way, we've done other presentations on this. If a notice of termination is recorded, you no longer have 90 days to record your lien, you only have 30 days. Let me say that again. If a notice of termination of the notice of commencement is recorded and served, the clock starts immediately and you only have 30 days to record your lien, not 90 days from that date.
Okay, perfect. Thank you so much for that clarification. Another question came through. It says, are there any options if the lien goes outside of the 1 year to foreclose?
No. You don't have. You have to foreclose on your lien within 1 year of the recording date of the claim of lien. The only possible exception, well, it actually wouldn't even apply. You still would have to have brought that action within 1 year. What I was going to say is you have a little more time to bring an action if someone records a lien transfer bond when they bond off your lien, but you still would have had to have brought that action to foreclose on the lien within that 1 year. No, so the only other recourse is to sue for other legal theories, as I mentioned, unjust enrichment, breach of contract, account stated, but your lien is no longer good.
Okay, perfect. Thank you so much for that clarification. Another question came through. Does a material supplier that is a fourth tier have lien rights?
Okay, so if we have an owner, a contractor, a subcontractor, and then a subcontractor, that would be the third tier. A material supplier to a subcontractor does have lien rights in the state of Florida. So if that's what they mean by fourth tier, which I think it is, then the answer is yes. As long as you are only providing materials, not any labor. So if you provide any labor, you would be considered a subcontractor, and you do not have lien rights. So if you're just providing, if you're a plumbing supply house and you're working for the subcontractor and you deliver toilets to the job site, that's fine. But if you deliver and install those toilets, you would be a subcontractor and you don't have lien rights.
Okay, wonderful. Thank you so much for that. Another question that came through, it says, I understand it is better to move quickly with the lawsuit, but if the lien is bonded off, is there a specific expedited deadline to file the lawsuit, or is it still within the 12 months from the recording date?
No, the time is still the same. Again, there's a slight wrinkle. If, assuming you've brought the original action within time, you have an opportunity to amend within 1 year of the lien being bonded off, but that's not the underlying time that you have to sue. So you should still do it right away. And again, my strong recommendation is if someone bonds off your lien, you should sue them right away. They bonded it off so that they don't have to pay you. So the only way you're going to get paid is to foreclose.
Okay, wonderful. Thank you so much. That does seem to be all the questions that have come through. If anyone does think of another question that hasn't been addressed, please feel free to reach out and we'll be sure to answer any questions for you. All right, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please remember every state has its own unique documents, deadlines, and lien laws, so please check that out if you are working in a neighboring state. There are project information sheets that you guys can use that help you get the information from the get-go of knowing who's working on that job and knowing who you need to be sending that notice to protect yourself. All right, and then the next slide, if you don't mind, please. All right, our next webinars with Alex are going to be September 18th. That's going to be chargebacks and bad checks suck, then do this. And then the other one will be November 20th. How do I get the bonding company to pay me? Please, we'd love to be able to see you guys there. You can register for free at sunraynotice.com/education. We'd love to be able to see you there. And then the next one, if you are going to be in the Miami area, Alex is presenting alongside of Ariella from SunRay for a live seminar on October 16th at 8:30 in the morning. This is going to be an incredible masterclass event. So please, we'd love to see you guys there. You can register on our website or use that QR code. Again, it's going to be a really great event for you guys to be able to kind of get the nitty gritty and information that you're looking for. And then the next slide, please. All right. If you don't mind, take a quick moment to give us a review on Google. We really do appreciate any feedback that you're able to provide to us. It really always helps us better ourselves and get the content that you're looking for out on these webinars. And then the next slide, if you don't mind. And that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you guys at our next webinar. Again, Alex, you really are incredible. We do appreciate you. So thank you so much for everything. I hope everyone has a beautiful and wonderful sunny day. Thanks again,
Thanks,
everyone.
everybody.